Distinguished participants, dear colleague, I'm grateful for this opportunity to give my overview about wartime crimes committed in Ukraine. I don't speak only about crimes under international criminal law, just because we have also another kinds of crimes, like crimes against humanity, and plus crimes against the national security, also the property crimes, and also we have in our criminal domestic legislation the proper provisions concerning the aggravating circumstances of commission of crimes in the terms of martial law. So few words about myself, just to add what was already told. I'm currently a visiting professor at the University of Neuchâtel. So in line with this, I continue to work with my Ukrainian students via online, give the lectures and overview my PhD students. So I also have a certain kind of mission at the International Commission of Jurists, where I fulfill a project regarding the development of Ukrainian criminal law after the introduction of the legal regime of the martial law in Ukraine. Before this very sad anniversary of 2 years of full-scale invasion of Russia to the territory of Ukraine, it's a special responsibility to talk today about the possible avenues, how to overcome all the difficulties, how to find a way to stop the war finally. Anyway, it's not only one avenue, because we should continue our path to European integration, to become the full member. So we have to plan how to restore our country after the end of hostilities. Not punishing Russian aggression would definitely set a dangerous precedent. That this would definitely mean that the world is ready to tolerate aggression. Today, I will also speak on to the certain points about reflections of international criminal law in the domestic legislation, about the prospect of its development. Ukraine. So you can see the Constitution of Ukraine, and here with me I also have the Criminal Code of Ukraine. So this is the current version, but of course we have already the draft of new Criminal Code of Ukraine, and in this draft there is the last section, which has already a very nice structure of the crimes against the international legal order, and also the crime against humanity, model crime against humanity, which is not currently available, in our domestic legislation. So Ukraine is a sovereign, independent, democratic, social and legal state, according to the Article 1 of the Constitution of Ukraine. The principles of rule of law, legality and justice apply to the entire territory of Ukraine. Of course, the extensive full-scale invasion of Russia to the territory of Ukraine caused numerous problems to the state, to its political, social, economic development. We should mention that on the 17th of June 2024, the European Commission recommended Ukraine European Union membership candidacy, and it's already on the 23rd of June 2022. European Parliament adopted the proper resolution regarding immediate candidate status to the for Ukraine, with the future prospects and the necessity to fulfill the special requirement, so-called Copenhagen criteria. Of course, if in the terms of the martial law, fulfillment of any kinds of obligations becomes more challenging for the country. After the 24th of February, more than 6 million of Ukrainian citizens moved from Ukraine, and it's also the problem of migration. That we hope that at least 60 or 70% of them will go back after the end of hostilities. Rebuilding and renovation of our country is obvious. Nevertheless, this would take some time and some expenses, but lives of innocent civilians, innocent people cannot be compensated. In this regard, the issue of accountability of also persons guilty in those horrible atrocities in Ukraine has a priority value, and it's not only for Ukraine but for the whole international community. It's just because this aggression pose danger not only for Ukraine, neighboring country, but also for international legal order in the general. So today I already told some words about the martial law. So what do we mean according to the national legislation by the martial law? This is a special legal regime introduced in Ukraine or in its particular territories in the case of armed aggression or threat of attack, danger to the state independence or its territorial integrity. The proper definition you can find at the Article 1 of the law of Ukraine on the legal regime of the martial law. And for the first time, the proper legal regime was introduced by the President of Ukraine on the 24th of February 2022. After this, so the legal regime was prolonged for a few times already, and the last prolongation also took place already after the 14th of February 2024. Of course, it's necessary to admit that this full-scale invasion gave rise to further development of Ukrainian legislation, and it's not only the criminal legislation. And this timely adoption of the legislation is logical due to the fact that it's always better to prevent the socially negative consequences than to deal with them after. In the terms of new kinds of internal and external threats, lots of acts were criminalized, and this gave rise to development of the criminal law of Ukraine. Also, I would like to address the fact that in the terms of the martial law, individuals who are the subjects to compulsory military service, mainly men between the age of 18 and 60, are restricted in their rights to leave from Ukraine. It's not only men, but also some categories of women state officials who are restricted. It's not the permanent restrictions logically, but for the period of the legal regime of martial law action. So pay attention, please, to the current legislation regarding this, covering these provisions. This is the law of Ukraine about mobilization, training, and mobilization. So Ukraine's martial law also entails temporary limitations of the constitutional rights and freedoms, not only for the natural persons, but also for the legal persons in the interest of the states. So key legal acts play a decisive role in protection of Ukrainian citizen interests during the martial law. So this is the law of Ukraine, legally provided martial law. Important to mention that the proper law contains no provisions about terms of its introduction. That means, in fact, that the legal regime of martial law can be prolonged and can last exactly as long as there is a need for this, and there is a threat to the independence and territorial inviolability of the country. So this legal regime can operate either to entire territory of Ukraine or to the particular territories, and according to the presidential proposal, can be terminated in the particular regions in the need. One more crucial regulation outlining the legal principles of compulsory expropriation based on the social necessity of property rights objects belonging to the state engaged in full-scale war against Ukraine. So according to the proper law of the basic principle of forcible seizure of objects of property rights of the Russian Federation and its residents, Russian Federation as a state is recognized as an aggressor state. And so the provisions of this article are in line with the proper United Nations General Assembly resolution regarding the definition of aggression. So now I would like to go to some extent to some statistical data and different categories of crimes which were committed since the full-scale invasion. So several thousand of crimes, it's even exceeding 100,000 of crimes have been documented and officially registered in line with a full-scale invasion to the territory of Ukraine. And among them, again, these are not only the crimes under international law, so crimes against the national security, against the children, so property crimes also exceeded crimes against the international legal order, environmental crimes, ecocide, which in the domestic legislation belongs to the group of crimes against the international legal order, and etc. So criminal proceedings have been initiated under the relevant articles of the Criminal Code of Ukraine, also against the official deputies, military command, other officials within the national jurisdiction. In the national jurisdiction is prescribed the proceedings in the form of in absentia. Okay, and this is definitely the relevant statistical data which can be found at the official website of Prosecutors General in Ukraine. So as of the 6th of February 2024, I should admit that every month, unfortunately, these indicators are increasing. So in these 2 last years, it was committed more than 100,000 of crimes officially registered, only officially registered. We should also keep in mind that there is the latent criminality which is not officially registered. So among the crimes of aggression and war crimes, qualification concerning qualification by the national legislation, crimes against the national security. In our domestic legislation, the crimes against national security are placed as the first chapter of the Criminal Code of Ukraine, which that means that in the that they belong to the priority social relations, priority values of the social relations in the state. Also, the crimes against the children, unfortunately, more than 500 children died and infringed more than 1,000 children. So yesterday I also participated in one very important and interesting event in Geneva regarding the avenues of to search the possible ways of liability for crimes under the international law in Ukraine. So before the full-scale invasion, yes, it's very timely to have such seminars and meetings just to make world, to remind the world that the war is ongoing, that is necessary to stop these atrocities. So according to the information of our prosecutors general in Ukraine, who was given also a talk yesterday, so more than 19,000 of children were forcibly transferred to the temporary occupied territories or to the Russian territories. So this is also contains the crime of genocide, as qualified like the crime of genocide under international criminal law. So a territorial fundamental case of aggression of Russian Federation with the involvement of military political leaders. So among them 683 suspected persons of ministers, deputies, and military commanders, heads of the law enforcement agencies. So this is very sad statistics. Anyway, this is the fact, and documenting is very important for the future building of the cases. So I also would like to describe to some extent how Ukrainian criminal legislation was developed after the full-scale invasion, because this war led to the criminalization of the social relations. What is meant by criminalization? This is an official recognition of an action as a crime. So martial law, legal framework itself used to be not that effective to provide the order in the society, and in this situation, Criminal Code of Ukraine became the strict priority regulator, and in this regard, in first 4-6 months after the full-scale invasion, our legislator have criminalized the certain acts and included these acts to the Criminal Code of Ukraine. It's different chapters. It was amended not only the special part of the Criminal Code of Ukraine, but also the general part in some provisions. So we will speak about some new, completely new criminal law prohibitions and some other criminal norms were amended due to the fact that the degree of the social danger increased in the terms of the martial law. For example, high treason. High treason is a crime against the national security in domestic legislation. Also, the second part of the Article 113, sabotage of the Criminal Code of Ukraine, currently contain the qualifying circumstance with the commission of the relevant actions of high treason and sabotage under martial law conditions. The sanction of this article contains two kinds of punishments, alternative punishments, either imprisonment for 15 years or the life imprisonment. Also, the Criminal Code of Ukraine was supplemented in 2022 with relevantly new criminal norms. So among them, Article 111.1, responsibility for collaborationism. What I should say about this article is very particular, consisting of 8 parts. So public denial by citizens of Ukraine of carrying out of armed aggression against Ukraine, establishing and confirming the temporary occupation of part of the territory of Ukraine, or public appeals by citizens of Ukraine to support the decisions and actions of the aggressor state. So it means that no longer consequences of these acts are needed, just a fact of the public denial or a public appeal already leads to the criminal liability of the person. In the case if the guilt will be proved. Very particular article still with the lack of developed practice. Responsibility also for the assistance to the state aggressor, Article 111.2. So disposition of this article gives us the following description of the action: intentional actions aimed at harming Ukraine by implementing or supporting the decisions, actions of the aggressor state, armed formations, and either occupation, administration of the aggressor state, a collection, preparation, or transfer of material resources or other assets to representatives of the aggressor state, its armed formations, and occupying administration of the aggressor state. So, as you see, this criminal norm includes its objective side, different kinds of alternative actions which can be further qualified as an assistance to the aggressor state. So some other criminalized actions belong to the internal problems in the state. They also took place and behavior of some individuals, their extensive social activity also on the internet, due to the fact also that there can be loss of disinformation, and that's why our legislator decided to criminalize such kind of actions. For the criminalization, I should admit, should be essential grounds, so-called complex, defined so complex of the social of the factors of social conditionality of the acts to criminalize the proper actions. So the unauthorized dissemination of information about sending, transfer of weapons, military supplies to Ukraine, Article 114.2 of the Criminal Code of Ukraine, and Article 201 of the Criminal Code of Ukraine, responsibility for the illegal use of profit from humanitarian aid, charitable donations, or free aid. Unfortunately, so displays of such actions also took place. That's why the proper action was criminalized. I also would say that in domestic criminal legislation, there is the list of the acts, the list of the circumstances in the Article 67, circumstances aggravating the punishment, and paragraph 11 of the proper circumstances is defined like the commission of the criminal offense under the conditions of the martial law. So that's why when qualifying the actions, this aggravating circumstance is also taken into account. So it was an overview of the special part of the Criminal Code of Ukraine. Of course, I would not analyze all the new provisions because it's not the limited list. There are also the crimes, property crimes in the national legislation, which currently contain also new qualifying circumstance, for example, commission of the robbery under the terms of the martial law. And sometimes we can define some controversial provisions in these norms. For example, the sanction, yes, for commission of robbery in the terms of the martial law. This is the Article 186, Part 4. So the sanction for commission of this act under the terms of martial law is the imprisonment for the term of 7 to 10 years. This of 7 to 10 years. The same about brigandism or visible street robbery. Also, this act is punishable by imprisonment for the term of 8 to 15 years with the forfeiture of the property if committed in the terms of martial law. And we have also, for example, the crimes against life and health of a person, intentional murder, in Article 115, which also prescribes the punishment in the form of imprisonment for the 15 years. So it means that, for example, intentional murder and robbery or visible street robbery have the same sanctions, the same long-term imprisonment. But there is a question if the value of life, for example, or the stolen telephone are equal. So probably our legislators should work a bit on the question of proportionality regarding these issues. So what else I would like to mention about the structure and recent amendments in our general part, in the general part of criminal code, not that much, but anyway, it's necessary to mention decriminalization of the infliction of harm to life and health of the occupants. There is a section of 8, the Criminal Code of Ukraine, circumstances excluding criminality of an act, and currently is supplemented by the new provision, discharge of duty and protection of the fatherland, motherland, independence and territorial integrity of Ukraine, which means as a fact that a person is not the subject to the criminal liability for the use of weapons, ammunition or explosives against the person who performed the armed aggression against Ukraine and for the damage or destruction of property in connection with this. Of course, when if no excess of the power take place, and of course in the absence of the signs of torture. So these are the current amendments in the criminal law of Ukraine, and now some words about national implementation and reflections, let me say like this, of international criminal law in domestic legislation. So there is the structure of the section 20 of the Criminal Code of Ukraine, criminal offenses against peace, security of mankind, and international legal order. And in this structure, you can find the criminal norms under the international criminal law. So crime of aggression, war crimes, genocide, but we don't have currently criminalized crimes against humanity. But as I already mentioned, our draft, new draft of Criminal Code of Ukraine contains very good structure of crimes against the international legal order. So this is an Article 437, planning, preparation, waging of an aggressive war. Which is a suspect crime of aggression under the international criminal law, and it's a crime under the Rome Statute of International Criminal Court. Article 438, violation of rules of warfare, war crimes, also among the crimes against crimes in the international criminal law. Genocide, crimes of all crimes, so also is criminalized in Ukraine. We have also criminalized ecocide. This is an Article 441. So I'm going to tell a few words about this crime too. Of course, there is no specific provision against the crimes against humanity, but Ukraine's constitution in its Article 9 states that international treaties, which are ratified by the Verkhovna Rada of Ukraine and are in force, are considered to be a part of the national legislation. In this regard, Ukraine became a state party to the International Convention for the Protection of All Persons from Enforced Disappearance in 2015. So currently I would like to address to the questions of crimes under international criminal law. So crimes against humanity, war crimes also. So based on the analysis of the available facts, the United Nations International Commission of Inquiry on Ukraine identified that Russia was involved in the commission of numerous war crimes in the territory of Ukraine, so which were expressed in the execution style murders of Ukrainian men and women, rapes, torture of civilians, mock executions. So also the report of commission contains information that systematic attacks on Ukrainian energy infrastructure and torture had the signs of the crimes against humanity which were committed by the Russian authorities. I remember also a year ago I had the lectures with my Ukrainian students via online, and sometimes it was really impossible to have this lectures to have these courses due to the outage of the energy in Ukraine. So here you can see some information. This is the schedule of hourly power outages in my native city, Sumy, in December 2022. Please pay attention that in the period of winter period, and winters are very cold in Ukraine, so the temperature may be about 22, 27, minus 27 degrees below zero. Yes, very, very cold. This is dangerous for lives of people. And currently, I don't have the lectures when there are notifications about aviation attacks, and my students follow to the safe places. Yes, but last year the biggest problem was with this damaged infrastructure and the impossibility to use energy when it was necessary to do that. So in line with the prohibited methods of warfare by international criminal law, by international instruments, they also used and currently use digital technologies with elements of artificial intelligence to disinform people, to spread again propaganda, to disorganize functioning of, for example, banking sector and the other important sectors of the social life. For example, the Center of Countering Disinformation in Ukraine informed that in 2022 it was spread the deep fake video with President Zelensky who addressed to the citizens and troops to lay down their arms and surrender the fight against Russia. Of course, it was further identified that this was so-called deep fake, but currently, if you probably follow the development of these technologies, currently the videos created by AI are very of high quality, yes, and sometimes it's really impossible to define which video is created by AI and which one is original. So this is also important to keep in mind. So the next crime under international criminal law is genocide. Independent International Commission of Inquiry on Ukraine concluded in March 2023 that currently no signs of genocide are identified in Ukraine. But I want to formulate the question, to ask the question, if those horrible actions and crimes which were already committed in Mariupol, in Bucha, and other cities of Ukraine, if these acts cannot be qualified like the genocide of Ukrainian people, and all my Ukrainian colleagues definitely agree and share this opinion that the genocide takes place. There is a genocide of Ukrainians which is committed. It's due to the fact that probably international community is not able to recognize the fact that at the age of development of digital technologies and artificial intelligence, the genocide occurs, and no one is able to stop it. And the war is undergoing, and other crimes are committed. So genocide is a crime which is not the subject to statutory limitations. It's also under the international criminal law and in domestic legislation. Genocide is a crime of all crimes, a willfully committed act for the purpose of total or partial destruction of any national, ethnic, racial, or religious group by extermination of members of such group or infliction of grave bodily injuries on them, creation of life conditions calculated for total or partial destruction of the groups. And I already told today about possible transfer of Ukrainian children, 19,000 of Ukrainian children from their native land, from their houses to the temporary occupied territories and to the territory of Russian Federation. So one more problem is the cultural genocide is a word combination which is not defined in international criminal law and international and the Rome Statute of International Criminal Law. But we also may give this proper definition to the events and those crimes, those actions which are currently committed in Ukraine. According to the data of the Ukrainian Ministry of Culture, more than 550 monuments and different objects of cultural heritage in Ukraine were destroyed or damaged by the Russian invaders. So Article 2 and 3 of the Hague Convention for the Protection of their Cultural Property contains the proper provisions as a protection and safeguarding the cultural property ratified by the former countries of the USSR. We currently have in Ukraine the proper register of the damaged and destroyed items and cultural heritage. So this is the proper collection, yes, of the information. One register of property damaged, and also so in my further talk, I will address back again to this question regarding the cultural heritage. So the law on compensation of damage, destruction of certain categories of immovable property objects because of the hostilities was also adopted in Ukraine in 2023, and Ukrainian citizens can apply through DIA, application DIA, which is available for every Ukrainian person who has a smartphone or any cell phone. So through this application, it's possible to apply for compensation for the damaged property. So you can see here also an example regarding the destructions of our cultural heritage. So on the 19th of August 2023, the city of Chernihiv, after the notification signal, the missile hit the roof of Shevchenko Regional Drama Theater as a result of so some people were killed, other received the injuries, and of course the beautiful premises of the theater also was partially destroyed. So damage to the cultural heritage and also to our environment. The mining of the Kakhovka dam and hydroelectric power plant also caused really grave consequences both for the environment of the country and the cultural heritage. Destruction of unique settlement of the banks of the Dnieper Southern Book, destruction of unique house of artist Polina Rayko, destruction of the monuments of the national importance, significant hill plots, the settlements of national importance registered and controlled also by UNESCO. So important today to provide the proper documenting of all these atrocities, of all these crimes, for further development of the cases. When once we believe that International Tribunal for Prosecution of Crimes of Aggression probably will be established. So another source where all these atrocities and damages are collected is emergency red list of cultural objects at risks in Ukraine. So as you see, all that information, results of flooding, information of about the objects, cultural objects which were damaged is currently stored in a special database also. So this definitely will take years to demine the territory of Ukraine, its agricultural lands, and of course, what is committed absolutely falls under the qualification of ecocide, which is the crime against the against the international legal order in the domestic legislation. This is the Article 441 of the Criminal Code of Ukraine. Mass destruction of flora and fauna, poisoning of air and water sources, and also any other actions that may cause an environmental disaster. So it's also environmental crimes which were committed, environmental crimes and ecocide. So these are different groups of crimes. Environmental crimes belong to the Chapter 8 of the Criminal Code of Ukraine, and ecocide belongs to the group of crimes against the international legal order. So the proper data also about official registration of environmental crimes can be found in the website of Prosecutors General in Ukraine. And also in line with these environmental crimes, so they were also officially registered for crimes of ecocide in Ukraine. Some factors which significantly affect the process of investigation of crimes during the war in Ukraine. So it's not the limited list of them, but to my mind, I would like to define some important factors that influence this process: geopolitical factors, legal factors, logistical also. So geopolitical factors so covers the questions of so disinformation, propaganda, so position of the aggressor state to investigate all crimes, so public speeches and talks about the special aims of special military operation, which doesn't exist, yes, as a fact. Spreading the false information, engaging in provocation, destroying evidence of crime, eliminating witnesses, displacement of these witnesses from Ukrainian territories to the temporary occupied territories or to Russian territories, to make them shut their mouths. This is very sad, unfortunately. The legal factors which influence the process of investigation of such crimes, warfare crimes, yes, not only the crimes under international criminal law. Some internal contradictions, I would say, in our domestic legislations. So lack of experience in the investigation of such categories of other cases, lack of developed practice, very fluent amendments to Ukrainian legislation. It's what we really, I would say, do very often. And in this regard, these amendments sometimes it's not easy to form the proper practice. Of course, currently there were developed already the bench books. There was developed a bench book for Ukrainian judges with the recommendations how to try the particular categories of the cases. But of course, so bench book and written recommendation and practice, which is formed also based on the peculiarities of the national legislation too. So there are the different questions. And logistical factors. So about access to some particular territories to collect the evidence. So lack of access both of national, domestic specialist, international specialist, difficulties with the forensic equipment. So sometimes it may be about also the bad weather, which influences to the possibility to preserve some evidence. So these are the factors that, to my mind, to some extent negatively influence the processes of investigation of warfare crimes in Ukraine. So about responsibilities and efforts to establish the special ad hoc tribunal for prosecution of the crimes of aggression in Ukraine, committed in Ukraine by Russian Federation. So there were national and international efforts to establish such a tribunal. So at the national level, I would like to mention, to address to the President Decree number 661 of 2022, according to which so was formed a 17-member working group, concluding the representative from the President's office, members of the Parliament, Ministry of the Foreign Affairs, Ministry of Justice, Prosecutor General, and representative from the non-governmental organization. And of course, the international efforts to establish the tribunal. So there were already some of the avenues developed, yes, but let me be honest, that important the result. Of course, every action is a new step and trace towards the purpose to establish the tribunal. But unfortunately, so currently we still don't have this tribunal. But probably what we had to do before to ratify the Rome Statute of the International Criminal Court, but today it is already obvious that Ukraine has no intention to do that, and no longer amendments will be introduced to the Rome Statute of the International Criminal Court. This was also a question under discussion yesterday with the foreign colleagues. So what were the international efforts to establish this tribunal? Core group on special tribunal, so consisting of the 33 countries supporting Ukraine and developing 3 possible scenarios for establishment of this tribunal. So one of them is establishment of special tribunal formed through agreement between Ukraine and United Nations, which is no longer possible, to my opinion. Multilateral treaty involving Ukraine and other concerned nations to establish a tribunal, and so-called the third way, so establishment of so-called hybrid tribunal, grounded in Ukraine but internationalized. So the next, also European Union efforts for the establishment of the proper tribunal. So European Parliament noting that the International Criminal Court has limited jurisdiction over the Ukraine-Russia situation, war, called for the dedicated international tribunal, and in May 2022 in the resolution stressed prosecution of Russia and Belarus for war crimes, crimes against humanity and crimes of aggression. So the European Union proposed 2 possible options for creation of this tribunal, an independent international tribunal through a multilateral treaty, or so-called hybrid court, which will be integrated to the national justice system. So there were also another efforts from governmental organizations for creation of the forthcoming tribunal. 2 main initiatives, 2 main non-governmental initiatives leading in the charge for justice procedures. So the Ukraine 5 AM coalition, comprising of 35 non-governmental organizations, dedicated to documenting of war crimes and crimes against humanity during the invasion of Russian Federation, and also the Tribunal for Putin initiative involving also different non-governmental organizations seeking for availability for the leadership of Russian Federation. Important role of independent international commission on inquiry in Ukraine in these efforts, as the commission collects and analyzes all the possible evidence of violations and abuses which were committed during the invasion, and so this documenting definitely will help for the prosecution of the suspected individuals after the establishment of such a tribunal. So the tribunal is not yet established. Let me see how the situation will be developed. But one of the important steps toward the establishment of the tribunal is the functioning of the International Center for Investigation of Crimes of Aggression in Hague, which started its work in June 2023, complements domestic, regional, and international efforts to promote accountability for the international crimes. Purpose of the center is so it's not about the prosecution, of course, because it's not the tribunal, but about coordination and collection of the evidence on the basis of which further it will be possible to build the proper cases in the court. So what is an importance and a role of the sentence? Is of course one more confirmation that the world is united, the world stands with Ukraine, and makes an effort to fight this Russian regime and make in all the guilty persons accountable for their crimes. International legal order. There is a question. If today international law are effective, international law provisions are effective, either we should speak about development of international criminal law and the further trace for development of international criminal law will be an establishment of tribunal for prosecution of crimes of aggression. That is timely and relevant question because Russian aggression is not only the threat to the independence of Ukraine and its an inviolability of its territories, but also it's a global threat to the whole international community, and I would say to the whole humanity. And the fact that today, in the era of artificial intelligence, the crimes of aggression and genocide are committed, it means that there are some legislative gaps which should be amended, yes, supplemented with new legal provisions. And in my opinion, such special tribunal for the prosecution of crime of aggression must and will become an effective means to ensure the individual responsibility of superiors and leadership of Russian Federation for the prosecution of crimes, for the commission of the crimes of crime of aggression against Ukraine. Thank you so much for your attention, and glory to Ukraine. Dear participants, I would be also glad to hear your questions. Probably you would like to address any topic or to discuss something or express your opinion, either to share your insights about our today's meeting. You're welcome.
I have a question. You previously mentioned in your presentation that there's no, like, the International Commission did not find the signs of genocide in Ukraine currently. But however, we do have some of the some parts of this war generally, they have some genocidal traits, like deportation of children, for example. Is it a problem of recognition? Does it lie in the current laws that are accepted, or is there any other ground for that maybe discrepancy between the reality and how do we recognize the genocides generally?
Okay, thank you for your question. So it's probably due to the fact, as I already mentioned, that genocide was officially qualified. So the displays of genocide and crimes of genocide were officially registered, and it means that these acts were qualified according to the national criminal legislation as a genocide. And this also the statistical data from the Prosecutors General official website in Ukraine. The fact that currently the recent events which took place in Bucha, in Mariupol, the proper commission of inquiry in Ukraine did not confirm the signs of genocide. So it's due to the fact probably that what we see from inside our internal vision and external vision differs so much. Plus, it seems that due to the fact that probably the world is currently not ready to recognize the fact that genocidal crimes are committed, because for the genocide also, if we will, for example, analyze the disposition of the articles, should be very clear evidence. For example, this can be also the public calls to commit a genocide for the proper qualification. So for the qualification at the national level, it's enough of the evidence to opinion for the law enforcement agencies and organs in Ukraine, but it's not enough for the commission. And it's very controversial because, as I already mentioned, no practitioners, no Ukrainian scholars, they still don't accept the fact that the international level, the fact of commission of genocide in Ukraine is not yet recognized. I think this is the task for us to prove in the future the fact of commission of the genocide, and that will be definitely proved. If I have replied to your question.
Yes. Thank you for the answer, and thank you for a nice presentation too.
Thank you for your question.
I see that Artem raised the hand. Do you have a question?
Yeah. Just, can you hear me?
Artem, yes. Pane Artem,
Yeah, sorry.
okay, I can hear you.
Yeah, sorry. I just have a follow-up question from the previous couple of slides. You know that there's some efforts being done. First of all, thank you for your presentation. It was very informative. I really liked it. But the question pertains to, you know, there has been some steps towards establishing an international tribunal for Russia. Yeah, particularly this slide. And I was wondering, how do the existing current political climate in America might affect that? For example, if let's say Trump comes to power and American isolationism is a way forward, how would that particularly affect sort of the legal international order and the preceding potential tribunal? Or is there a potential for perhaps maybe for a European-led initiative on this front?
Okay, I will try to formulate my opinion. Of course, it's regarding the establishment of the tribunal. There have been lots of discussions, and it's already for 2 years that we are waiting for the establishment of the tribunal, and different possible ways and means were examined, and different efforts were developed currently. So if there are any external factors which can influence the establishment of the tribunal, this is an interesting question. So there are always the factors, yes. In our case, they are more external than internal. Probably because it's my own vision, it was really important to ratify before the Rome Statute of International Criminal Court. There had been also the discussions when I was, for example, in Brussels, that probably it would be easier to make some amendments to the Rome Statute of International Criminal Court. But again, so from my interactions with the colleagues at the international level, we should also realize that this way is impossible. So in this situation, this is the main task of the national judiciary, of course, to prosecute all these crimes which are possible to prosecute, for example, in absentia. Yes, the role of international tribunal is complementary role. Of course, we cannot deter, for example, Putin and his, let me say, accomplices. Yes, so no clear answer to this question currently, but it's obvious that probably some external factors can influence the establishment of this court, but it doesn't depend, I guess, on any country. If this USA can influence this process, or European Union, it should be a clear mutual decision. Yesterday, again, I had a discussion with one of the colleagues from Ukrainian Bar Association, and the topic of discussion was again this international tribunal, and there was expressed an opinion from her side that if for example, Ukraine will finally, if for example this court will be finally established, that probably Russian Federation and China can establish another ad hoc court from their side, yes, to prosecute criminals, how they can model this, yes, from our side, yes. But anyway, they can do this even with or without establishment of the court of aggression. So this is my answer to your question. I don't think that is a particular influence of the USA or at the procedure of establishment of the court. There are another barriers which influence this process, and plus, again, discussing this question with the colleagues from ICG.
But in your opinion, how realistic do you think the idea of obtaining justice possible?
Once this definitely happen, but this will take a lot of time, and of course, what we can do at the national level, we should do maximum, because first of all, This, of course, is international armed conflict under the international criminal law, but is our, first of all, it's our problem, national tragedy. That's why, so the national courts in this situation has to do maximum to prosecute those persons who can really be prosecuted, even, for example, in absentia, without their presence.
But in
Thank you.
absentia, then we will still like have the same situations what happened to those responsible for the MH17, right? They're prosecuted, but nothing is really being done to, put them forth to justice. So we'll just have, the same thing. No?
But let we be honest. Today we share our interpretations. Yes, interpretations that what possible scenarios can take place, but we should follow the reality. I totally agree with you that the difficulties can arise even after the courts deliver the decisions. The decisions should be enforced, and this is already another problem.
All right, thank you.
Thank you also for interesting question. Any other questions? Any other comments, insights? Dear participants, colleagues?
If I can do it again, I'll do it again if no one is wanting to go. I'll have a second go at this. I've actually been reading a paper on transitional justice, this idea of having amnesties, which is really applicable to civil conflict and pertains mostly to civil conflict in Africa. But I think it might be relevant. But what is your general opinion on this idea of amnesties, sort of granting post-conflict amnesties to Russian, criminals? Yeah, let's say that, as opposed to justice.
So I don't support this idea. So it makes no sense. Again, we are talking about international crimes. So the crimes which are dangerous to the whole humanity. Without the terms of limitations, the periods of limitations. So in this case, it makes no sense due to the gravity of the acts which are committed. So if we are speaking about you mean the responsibilities of superiors, yes. Plus, so it's probably even in the terms of transitional justice will be not in line with the contradictions, not in line with the tasks of the criminal law and criminal punishment as such. For the punishment, we are talking about the need to correct the persons, yes, correct and prevent the further crimes, correction and prevention. For the crimes under international criminal law, I guess it makes no sense if we are speaking about domestic legislation, again, depending on the qualification and mitigating circumstances for some categories of persons. Again, criminal law is a law when we are talking about individual criminal responsibility, yes, individual characteristics, complex of mitigating, aggravating circumstances, plus what can be applied outside of the territory of Ukraine can probably not be applied in domestic, in terms of domestic, let me say, prosecutions, because due to the fact that even some outside of the criminal, for example, prosecution, some alternative means of disputes resolutions are still developed, like mediation, for example. The same, I think about transitional justice, that still not that applicable, probably in this situation.
You know, I think I'm thinking more about civil wars, yeah. Because I think the biggest issue with the case of Russia is that, you know, they're the neighbors. So we'll have to live with them anyway, right? And so there has to be some sort of degree of reconciliation and normalization of relations, at least in the long run. And so I'm just wondering how that's possible.
It's a long-term perspective, but so currently probably it makes no sense even to speak about this due to the fact that every day we have new victims, we have new destructions, so new evidence of crimes are documented. So probably it's not that timely to talk about that. At least this is so we should, all of us, we should live in peace, and they say that better we have bad peace than good war. I will definitely will not agree with that opinion that war is a war, peace is a peace. But how long this will take, and how long this will take to restore these relations between the countries, to stabilize the situation. So the years after the end of hostilities, generations, I guess, yes, probably we will not see that, me and you and the other participants, because this is the trace and injury, yes, for generations, which will stay in their hearts and minds and history of Ukraine.
All right. Thank you.
Thank you. So dear participants, any other questions? It's really special for me to give, was really special for me to give this talk today, before this anniversary, yes, before the 2 years of invasion. And of course, I really wish to wake up tomorrow with excellent news that the war is finished, that we can go back to Ukraine, to our houses, and so we have to keep our hearts open and to be optimistic about this. So if you don't have any more questions, I am really grateful for your presence today, for the questions which were already asked. I really hope that this is not the last meeting for us, and that we will have another meetings maybe at the university in Zurich, or either at the University of Neuchâtel. But let it be another good topic related to the post-war recovery, victory, and nice and peaceful life. Thank you very much.